Good afternoon, everyone. We'll proceed to hear the cases as they're listed on the docket in their order. Appellants, please remember you can request rebuttal time. You can save some time from your argument and say, I'd like to reserve up to 5 minutes for rebuttal. The other thing is just a cautionary thing. We live stream these things. So what you say goes out to the internet, the web, whatever, all corners of the world, I suppose. So you might be mindful of the things you say so you don't regret something. Are there any announcements or introductions? Seeing none, would you call the first case, please?
Todd Michael Perkins versus Elizabeth Mundy, Perkins Sloane.
Good afternoon, Your Honors. Russ Edwards from Hendersonville. I represent the appellant. I would like to reserve 5 minutes, please.
Okay, 5 minutes.
I will be mindful of what I say. I won't be too critical of the trial court, who I've had much respect for many, many years. But we do feel that the trial court erred in this case. I'm going to refer to the parties as wife and husband, even though they're already divorced. I think that makes it so much easier trying to discuss who the parties are. And I'm more than willing to answer any tough questions the court has, and you can interrupt me at any point, and I won't be offended. I kind of look at this as my opportunity to answer any questions the court has. But be that as it may, we're here on a marriage of what some consider to be a short-term marriage by some standards. The parties were married for 3 years and 4 months, but they accomplished a lot during that time. They accumulated a lot of properties, 4 rental properties, and they even built a house. My wife and I have been married for 25 years, and they bought a lot more, accumulated a lot more than we have during that time. So, but the trial, it was all bought during the marriage. There's no dispute about that. So we're talking about 5 properties. The trial court classified all of these as the husband's separate property, all 5 of them. And that's our first issue, that the trial court erred in its classification of the properties as separate versus marital. And I can't, well, I'll just say I can't see the trial court's rationale there. Of course, I'm not the one making the decision here, but I think it's clear that these are all marital property, as that term is defined under the statute. And so I'm not going to spend a lot of time on the classification issue unless the court directs me otherwise and wants to spend.
Is that because the property was acquired during the marriage?
Yes, sir.
Which that's a rebuttable presumption that can be rebutted, right?
It can. It can be rebutted. It was bought during the marriage, and it's our position that the husband did not rebut that enough to change to classify it as separate property.
Counsel, the funds from husband's salary, and putting aside the different accounts and the money from his salary that was making during the marriage, was that used towards all 5, making payments in connection with all 5 properties, or just the 3 later rental properties? Which properties were husband's during the marriage salary funds used with regard to, of those 5 properties?
I believe he used all. I mean, it was used, I think it was spread out. It was used to make payments for the, primarily for the construction loan, for the construction, and after it was built, the mortgage on the marital home that they built.
And some of these properties are also sort of running behind, it's my understanding, in terms of not fully, the rental wasn't fully supporting, so there was some supplementing going on from out of husband's salary, right?
Yes, sir, because the rental properties, a lot of them paid for themselves. With the rent they accumulated, paid for the expenses, but there were some shortfalls.
And funds from husband's salary was during the marriage, that he was making during the marriage, was used to address those shortfalls.
Yes,
And that's with all of the properties or just some of the properties?
I believe he did that on all of them. And if I'm on the properties, I don't think, there might have been one or two that actually paid for themselves, but like most rental properties, there's always some shortfalls. And they, but yes, he used his income for the purchase of a lot of these properties and maintenance of them, and the wife did too. She used a lot of her assets towards the marital property, purchase of them and acquiring of them and maintenance of them. And we'll admit the husband used $95,000 of his premarital funds to invest in these properties. That was the initial investment. That's been undisputed. But assuming if the court finds that the trial court erred in its classification of these properties, moving on to the division, what the trial court did was found that these properties were all separate, but still did a marital property division analysis. The court went on to say, to talk about how these should be divided on a marital, as if they're marital property. And the court discussed the two cases of Batson and Powell, which is in Batson v. Batson, that was decided in 1988 by the Court of Appeals. And the court there held that they restored the parties to their premarital positions financially because it was a short-term marriage. However, one of the distinctions in Powell and this case that we're here on is that a large portion of the marital estate that was divided consisted of the parties' premarital or separate assets. It was an IRA, and I think the husband was a doctor, and he was trying to collect on some accounts receivable. And this was discussed in Powell. Powell came out 15 years later in 2003 from the Tennessee Court of Appeals, and it didn't completely overrule Batson, but it came very close. The Powell court was very critical of the Batson holding, and in Powell, what the court did was equally divide the marital assets that accumulated during the marriage, and that marriage lasted 4 years and 8 months. So it was not very much longer than the marriage in this case. But the court in Powell equally divided the assets. So the trial court was wrong in following the Batson approach. So we're asking that the court follow the Powell approach in this case.
Can I take you back to classification for a second?
Yes, sir.
Is Switchboard the property that that wife was listed on the property for? That's the particular property that she was actually listed on the property for?
It was.
Then the trial judge, though, had it listed as a different property, was the one that she had been listed on.
Yes, the trial court, I think, misclassified the properties or misnamed them. Switchboard, that is jointly titled.
And the mortgage here was in both of their names. In this case, the trial court said that it was just in husband's name.
Correct. And I think honestly, I think the trial court got those confused because the Switchboard property, you're correct, the mortgage and the title are in joint names. That was the first rental property purchased by the parties. But in going back to Powell, how Powell should be followed in this case, because the Powell court held that Batson is not controlling in a case such as this one here, because Batson consisted primarily of an increase in value of the husband's separate property during the marriage, and I already said that. But Powell involved a majority of the estate that was acquired during the marriage. And all of the property that we're proposing to be divided in this case was acquired during the marriage, just as in Powell. Also, in the case of Galligan v. Galligan, the Court of Appeals held that the holding in Batson does not control in all marriages of short duration. The Batson court, as well as the trial court here, focused very heavily on the duration of the marriage. And that's one consideration, statutory consideration in dividing the marital estate. But the duration of the marriage should not always carry more weight than other statutory factors. But what we're not up here just complaining about what the trial court did. We actually have a proposed division. And this is what we proposed to the trial court. And in lieu of just remanding this back down for the trial court to make an equitable division, we've made a proposed division that equitably divides what we consider to be the marital estate. And that's outlined in page 39 of my brief and in table 3. And it's equally dividing the property, but first giving the husband back his initial investment into the marital estate of $95,000. So it's not a complete equal division, but it's fair, it's equitable, it's giving the husband back his initial investment and dividing everything else 50-50. So that's what we've proposed, and we highly suggest this court soldier on and make an equitable division in this case. Thank you.
Thank you.
Good afternoon. Let me get up here so I'm on the camera, I guess. My name is William Moore, and I represent Mr. Perkins in this matter. And the issue before this court, which is the seminal issue and the gravamen of the case, is the classification of these real properties. That has outcome determinative consequences as to the division and the other thing. That's why you have to look at the classification first. And the standard of review for this appeal is whether or not the classification, which is a finding of fact, is supported, not just supported by the evidence, but if there is given a presumption of correctness unless the evidence preponderates against the court's findings. And it is our position that there is no evidence that preponderates against the court's findings.
Counsel, what do we make of the switchfoot or switchboard property where the trial court and trial court seems to have gotten confused between which property was titled in both names and whether they're both on the mortgage or not on the mortgage? And isn't that a preponderates against, at least with regard to that property, where the mortgage looks like it has both and the property looks like it has both?
No, sir, not at all. What Justice Usman, in that case, and the record is clear, that Mr. Perkins was advised by his real estate agent, rightly or wrongly, that he came from Indiana, he had to title these properties in both their names. Now, that's evidence. He didn't intend for that to be that way, as evidence because every single financial contribution to all of these properties, including the switchboard property, which was the first property, and every other titled property, including the marital residence that was acquired after the switchboard property, was titled only in Mr. Perkins' name.
Was husband using funds in this case to meet shortfalls with regard to these properties that was from his salary during the time of the marriage?
And that is true. However, we still go back. The Corbett decision is insightful on this case, as cited in our brief, and is also cited in the memorandum opinion of Judge Thompson, where it says the earnings are considered marital property absent an intention of the parties to keep those separate. The fact of the shortfalls were from the earnings does not, because of Corbett, does not create a jointly or marital estate from those funds, if they're all from his funds. And we brought Mr. Vance, a forensic accountant, who examined every single account of both of these parties. Not one penny of the wife's earnings went toward contributing to any of these properties.
To the properties or to the accounts?
Both. All of the accounts that funded these properties were separate accounts. And that has two consequences, may it please the court. First of all, it says the contributions were from Mr. Perkins' separate property. Moreover, as found by the trial court, that manifests an intention, which is the exception to the property acquired during the marriage, that manifests an intention to treat these properties as separate. Not only does it manifest his intention, but the lack of contribution, which is de minimis, as found by the court and supported by the evidence, and the evidence doesn't preponderate. The lack of contribution by the wife manifests an intention that she intended for these properties to be separate.
Wife asserts she engaged in physical labor at these properties. She was involved in tearing out the carpet. She's involved in sanding the walls. Did the trial court here accept that she engaged in that work and the only concern was the lack of clear valuation of that work, or did the trial judge reject that she had engaged in that work?
I don't think the trial judge gauged it, but in order to evaluate what that contribution was, and keep in mind, in marriages of short duration, is that, I don't know if that's intangible or intangible contribution, but nevertheless, the court's faced with, how do I value that? And it's up to the person asserting that position to come with some amount of proof, not just that it was done, but what the value was. And that's totally absent in this record. It's simply again, that manifests an intention that they keep this property separate. The one exception to that is not the real property, but the fact that Mr. Perkins funded from his earnings a retirement account for Ms. Perkins. She didn't contribute anything to that. And if it please, I'm reminded, I like analogies, and we learn a lot of stuff when we're little children, and I'm reminded of a thing on Captain Kangaroo. It was called the Little Red Hen. Little Red Hen was in a barnyard. She had friends, a cat, a dog, and a bull, and she found some seeds. And she says, who will help me plant these seeds to grow wheat? And none of the friends would contribute. She says, well, who will help me cut the wheat when they grow and take it to the mill? None of her friends would help. She said, well, who will help me take the flour and bake the bread? So we don't want to have anything to do with that. And then later, well, who will help me eat the bread? Well, they all held their hand up, and Little Red Hen says, no, I'll do it myself, like I did all the work myself. That goes to really a principle of equity, which underlies all of the legal statutes and case reasoning, is that there has to be some sort of contribution not just because of the equities itself, because it manifests an intent. Are we treating these properties as separate? When it comes to the work and the contribution and everything that gained, and they all came originally from separate funds prior to the marriage. Therefore, the presumption of classification was as marital property because it occurred after the marriage is rebutted, and there's no evidence to the contrary. Therefore, the contributions were minimal, and the equities, and most importantly, the result is the parties intended for this to be separate in terms of its contribution, and that's why it should say the same. Two quick matters on the attorney's fees that they're requested. We're under the American Standard rule. This is not a question of child support, alimony, so attorney's fees on appeal should not be available. And as far as the timing of the retirement account, the law is clear under the subsection 32(1)(c). It's the date of the decree of the divorce, which was March the 24th, 2022, not when the division was made.
What about increases in the value of the property? I'm going back to classification.
Right.
Again.
If the increase in value of separate property, it shall remain separate property, even though it occurs during the marriage.
So the fact that it's separate, stays separate.
And it's treated as such.
Even if she did some work that made it more valuable.
Well, we don't have, how do we quantify that? I don't mean to answer a question with a question, but there has to be some evidence put forth as to the value of that property. Moreover, she couldn't even point to which properties that she did make those contributions.
Okay.
And even going even one step further, her, as far as treating everything separate, all of her earnings she kept for herself. She didn't make any mortgage payments. She didn't, and she didn't contribute to his education. Judge Thompson went through a question on page 257 of the trial record where he asked her about those contributions to his ability to earn. Never made that. They operated separately, both from professionals.
Providing funds while he was getting his degree. I mean, so he's getting his degree. They're living together. She's paying they're paying rent on a property from her family during that time period while he's getting his degree that allowed him to make a very healthy salary.
Again, where was the evaluation of that? It was just, oh, well, they did that, but we don't know what it was. So how can the judge evaluate what that contribution was and put a dollar figure on there? It's incumbent upon one who makes an assertion that there's been a contribution to at least give an idea of what that contribution is. And that's totally lacking here.
Returning to your red hen illustration, is the problem here not that the red hen didn't get help, but that we don't know what the value was of the help that the red hen got here? That might be a woodchuck question, how many woodchucks, but is that essentially what the core problem is with the contribution in this case?
The lack of that and really the finding, first of all, that Mr. Perkins was a credible witness, okay? And there was silence as to whether Ms. Perkins was a credible witness. He didn't say she wasn't. However, there was a lot of discussion about whether she had actually remarried pending the divorce. She testified in her deposition that she had married. When we deposed her spouse, there was contradictory testimony that they had been married. We still don't know. And there were questions regarding, well, accounts that she was on with her new spouse and she said no, but when we get the accounts, there were a lot of issues of credibility concerning inconsistent statements of the spouse. But be that as it may, the court admittedly did not make a finding that she was not a credible witness, but there is certainly evidence in this record to assume. At the end of the day, we get down, there is a presumption of correctness in the court's finding unless the evidence preponderates, and there is no evidence that preponderates against the court's finding. If there are any questions further, thank you all.
Thank you.
I just told my age when I started talking about Captain Kangaroo, didn't I?
Well, I remember the captain, so I guess that makes me just as old.
Just to hit on what you were saying, Judge Usman, what you were asking about, we do have proof of the increase in value of the assets, and we have the purchase prices of all of these properties, and we also have the current values of these properties. And the statute is clear that you value assets as close as possible to the date of the division of the assets. The parties were divorced prior to the final hearing and the final court's decision where the court divided the property, but the statute says it's supposed to be as close in time as possible. So we have definite proof of how much these increased in value during the marriage. And I would like to say that rental income is certainly marital property, and any income earned from either party is considered marital property.
Even if it's from separate property?
Well, I can say rental, the law says any rental income, that's from a Court of Appeals case, any rental income earned during the marriage. But it's our position, these are marital assets. And I would like to, the husband here argues a similar point as the husband did in the case of Powell that I previously discussed. In Powell, the husband stressed the wife's limited involvement in the business that was deemed to be marital property. And it was some check cashing businesses that the husband owned. It was a family business. And the court ultimately equally divided between the parties. The husband claimed that the wife's lack of participation somehow negates her right to share in the increase in value of the business. But this argument didn't work since the Powell court held that even in a marriage of short duration, both parties are entitled to share in any increase in value of marital assets. I would like to just speak briefly about the issue of attorney fees. It's adequately briefed, but we're asking that the court award the wife all of her unpaid attorney fees and costs incurred. And the new statute, relatively new, that came out in 2022, classifies unpaid attorney fees and costs as a marital debt to be allocated justly, which means equitably. The trial court here awarded the wife 1/4 of her incurred attorney fees and ordered that she pay her own expenses. So we ask that the trial court be reversed in that regard and award her all of her attorney fees incurred, unpaid attorney fees incurred at trial and all attorney fees incurred on appeal. So,
Counsel, for the appellate attorney fees, does this fall within the scope of statutory provision with regard to attorney fees awards on appeal?
I can't answer that. I know the statute says all unpaid attorney fees. I don't think it removes fees incurred on appeal. And I don't think, I'd have to go back and read it. I don't think it just says incurred at the trial level. Unless the court has any further questions.
Don't see any. Thank you.
Thank you for your time.
Thank you both. Would you call the next case, please?
Travania Dudley Henderson versus Robert Dwayne Johnson et al.